Major breaking news and a shocking bit of news. The Senate Parliamentarian has just ruled that the removal of suppressors and short barrel rifles and short barrel shotguns from the National Firearms Act cannot be done through the reconciliation process and must overcome instead a Democratic Senate filibuster. This is crazy, a crazy decision. Insane in my view. And you know I'm not Mr. Hyperbole when it comes to giving you the facts as I see it on the ground. I cannot believe that this is the ruling from the Senate Parliamentarian. We're going to break this down when we come right back. But in my view, this is dirty pool. Very dirty pool is being played in Washington, D.C. against Americans and our freedoms. Let's talk about it when we come back. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, this is terrible, terrible, pathetic, awful, terrible news, scummy news, dirty pool news. And you know I'm not Mr. Hyperbole, but what I'm about to describe to me is ugly, nasty, and total BS. The Senate Parliamentarian has just ruled that you cannot, meaning the House and the Senate cannot remove from the National Firearms Act suppressors, short barrel rifles, and short barrel shotguns. Even though the National Firearms Act is undeniably 1000% a taxing scheme, don't take my opinion. Take the 1937 unequivocal central holding of a case called U.S. versus Sunzinski, a case that was reaffirmed by none other than the majority of the Supreme Court in 2012, written by establishment Supreme Court Chief Justice John Roberts in National Federation of Independent Businesses versus Sebelius, using as an example of a taxation scheme that has the secondary effect of regulating something, the National Firearms Act and the case of Sunzinski itself. But nevertheless, the Senate Parliamentarian has just ruled that somehow, some way, you cannot remove these items from the National Firearms Act taxing scheme because it violates the so-called Byrd rule. Now, let me tell you my honest view, in my opinion, what this situation reminds me of. You may recall from that scene in Star Wars where they're overlooking the Mos Eisley spaceport, Luke Skywalker and Obi-Wan Kenobi and the droids. And Ben Kenobi, Obi-Wan Kenobi says that Mos Eisley spaceport, you will never find a more wretched hive of scum and villainy in the universe. Well, the reality is Obi-Wan Kenobi got it wrong because he must not have been familiar with Washington, D.C. What just happened here is inexcusable. As you know, there are many instances I make excuses for people. I say I think there's different ways of looking at this. I understand why there's a debate. When it comes to not being allowed to use the reconciliation process, which is designed specifically to modify mandatory spending issues, which this does not relate to, and taxing issues, which this does, there is no way on earth, in my view, that you cannot remove, or you could not remove, suppressors, short barrel rifles, and short barrel shotguns from the National Firearms Act, which are items that are little being taxed. Literally the only federal hook that Congress could touch fingers with these items is under their taxing authority in Article 1 of the U.S. Constitution, which is exactly what the Supreme Court said in 1937 in the Sunzinski case, reaffirmed in 2012 by Chief Justice John Roberts and the majority of the Supreme Court in the Sebelius case. These are taxes. Now, the excuse, presumably, by Senate Parliamentarian here, Elizabeth McDonough, is that the effect of this regulation is more regulatory in nature than taxation. That's BS. BS. Congress doesn't have the authority to regulate firearms. They have the authority to do various things like tax firearms, possibly, in certain ways. But they don't have the express authority to just regulate firearms without touching fingers with either interstate commerce, which no one suggests that the NFA is about that, or giving rise to taxation schemes, which is what the NFA is. Nevertheless, according to reporting from Stephen Gutowski over at The Reload, this is what the Parliamentarian just did. The Senate's top rulemaker has determined the effort to delist silencers, short-barrel rifles, and shotguns, and other guns from the National Firearms Act of 1934 does not fit within the budget reconciliation rules. Just after midnight on Friday, Senate Budget Committee ranking member Senator Jeff Merkley, a Democrat, announced the NFA provision did not comply with the Byrd rule. This is crap. Sorry. There's no other argument on this, in my view. It's just crap. In fact, if you look at what the Supreme Court said literally about the National Firearms Act and the taxation, and they reference machine guns, but they're talking about the NFA items. This is what the Supreme Court literally said in 2012 about the NFA and what it is and Congress's power to deal with it. Here's what the Supreme Court wrote about the NFA. Quote, "None of this is to say that the payment is not intended to affect individual conduct. Although the payment," and they're referring to the Obamacare payment, the insurance payment, "will raise considerable revenue, it is plainly designed to expand health care coverage. But taxes that seek to influence conduct are nothing new. Some of our earliest federal taxes sought to deter the purchase of imported manufactured goods in order to foster the growth of domestic industry." Chief Justice John Roberts continued to say, quote, "Today, federal and state taxes can compose more than half the retail price of cigarettes, not just to raise more money, but to encourage people to quit smoking. And we have upheld such obviously regulatory measures as taxes on selling marijuana and sawed-off shotguns. See United States versus Sanchez and Szynski versus United States. Indeed," Chief Justice Roberts writes, "every tax is in some measure regulatory. To some extent, it interposes an economic impediment to the activity taxed as compared with others not taxed." It's a tax. It's fundamentally a tax. That's it. The purpose of reconciliation is to allow Congress to make modifications to taxing authority and taxing schemes under federal law and to deal with mandatory budgets. Now, we're not dealing with mandatory budgets with the NFA. We're dealing with a taxing scheme. If the NFA and taxing these items is not taxation, is not part of Congress's taxing authority under Article 1, it can't even exist. Which gives rise to the backup plan, apparently, according to the reporting of Stephen Gutowski over at The Reload, that the backup plan, according to reports, is that the next step is to remove the $200 tax off these items and leave the registration requirement and the fingerprinting requirement in those items. This is what Stephen Gutowski wrote over The Reload about this. The decision means that the Senate's version of the NFA proposal is likely dead. It's a major setback for gun rights activists who pressured Republicans to push for full delisting after the House Ways and Means Committee initially proposed just eliminating the $200 tax on the devices. However, Republicans could rerun the proposal through the parliamentarian process in its original form, as they've successfully done with several other provisions that were initially stripped out. That's something that gun rights activists have planned as a fallback if full delisting, which would not just eliminate the tax, but also the registration requirements on the devices, was tossed out under the Byrd rule. Now, that's a perfectly fine strategy in one sense, but it's crap. And I'll tell you why. Because the only basis, the only hook for allowing a registration of gun owners and gun registries in any respect touching fingers with these devices under the NFA is as a mechanism to ensure compliance with the tax. Congress doesn't have the authority to create a gun registry or gun owner registry. They lack that authority under Article 1 of the U.S. Constitution. They do have the authority to create taxes on certain items, which is what they've done, consistent with Supreme Court precedent on suppressors, short-barrel rifles, short-barrel shotguns, machine guns, and the like. And they are allowed to come up with enforcement mechanisms to ensure that tax has been paid, that stamp tax has been paid on those items. And one of the enforcement mechanisms that has been come up and that is deployed is the registration requirement and the fingerprinting requirement. But if you remove the $200 tax from the items under the NFA, then there is no more Article 1 authority hook, if you will, the hook for the power or the authority for Congress to act to insist upon registration or any of those other things. So here you have apparently the Senate Parliamentarian is prioritizing the registration and regulation of these guns over the taxation component, but she's got it ass backwards. Because the registration requirement, the fingerprinting requirement, these regulatory components of the National Firearms Act are derivative of the primary purpose of the NFA, which is the taxation scheme. And it must be that way because under Article 1 of the U.S. Constitution, Congress has the power to tax things, but Congress doesn't have the power to create registration and fingerprinting and these other regulatory requirements involving these types of firearms and these types of items, except as a tool or mechanism or means to ensure the taxation component is satisfied. Yet the Senate Parliamentarian has prioritized the regulatory effects of the registration and fingerprinting and those other schemes and downplayed the tax, when in reality, those are supplemental to and derivative to the primary purpose of the NFA, which is a tax. Now, as to what's going on down there in Washington, whatever it is, either there's incompetence or tomfoolery or dirty pool or something. I can't speak to that. I'm not in Washington. I'm not directly involved with any of this stuff. I'm following it like you all are. But I'm not talking to these politicians or these people involved with this process. But I will say there was an interesting tweet that went out, and I'm not standing behind this tweet or saying it's true, but I want to give you this information because I want to give you this full amount of information that I have, and whether this is correct or not, I don't know. But I do want to flag something that was said by Sean Davis, the CEO and the co-founder of The Federalist, which I do think is an excellent publication with Molly Hemingway and that gang over there at The Federalist. The excellent publication. And Sean Davis tweeted out this on X. He tweeted out, quote, Senate GOP leadership is deliberately using the parliamentarian as a foil, implicitly blessing her removal of key provisions they wanted out but they didn't want to vote against as a means of creating negotiation leverage against the House. Now that may be true, but I'm not sure about that because here's the thing. Even if the Democrats wanted the NFA provisions to violate the Byrd rule, and even if Republicans wanted the same hypothetically for the sake of argument, the Senate Parliamentarian still must do her job. And if she does her job, there is simply no way, in my opinion, for her to find other than removing these items from the NFA is essentially a taxation component that is removing major tax revenues from the federal government. Right? Because it's millions, if not tens of millions, if not even $1 billion+ over the course of the next 10 years if you add it all up. It's a major chunk of change. By removing these items from the NFA, you are impacting the federal budget. It is a huge number. But even if it were not a huge number, it wouldn't matter because it's still a tax. Even a small tax is a tax. As we know from the 1960s, the Harper versus Board of Election decision with a $1.50 poll tax was unconstitutional. Now, these are not identical issues, but you get the point that even a de minimis tax, even a $1 tax to be able to have the right to vote is a tax. And as we know, the power to tax is the power to destroy. So with that said, I'll keep you apprised. There's a lot of other excellent Second Amendment YouTubers out there, a lot of gun rights groups in particular. The Gun Owners of America is doing a fantastic job, working on this issue and tracking this issue. So I encourage you to watch them, minute by minute to track this. They're much more up to on all this than I am. All right, folks, so there you have it. I wish I could bring you better news, but this is terrible and inexcusable in my view. And I'm not Mr. Hyperbole, but there is many words that I would like to use that I will not use in this video, but it is unacceptable and inexcusable and pathetic. And this decision is baseless, in my opinion, by the Senate Parliamentarian. And I understand that there are line calls out there, there are close calls out there in certain things, This is not one of them, in my view, given clear Supreme Court precedent and that this is clearly a budgetary taxation item that clearly satisfies any Byrd rule issues. Just pathetic. Just pathetic. Okay, folks, so there you have it. Hope you appreciated this video. I'm not going to say enjoyed it, but I hope you at least appreciated the information I shared. Make sure you follow me on X at 4 Boxes Diner, and don't forget to subscribe both to YouTube and to Rumble here on this channel. I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.